corrupt netas. The SC has said corruption taking gigantic proportions. The top court has also said that corruption affecting the governance. It's also made another statement saying that corrupt officials cannot be let away. Don't take lenient view against the corrupt. It is in fact demoralizing the effect on honest officers, and conviction can be based on circumstantial proof. So no lenient view against corrupt officers. So that's the big breaking news that we're tracking at the moment, where the top court on corrupt netas has spoken. In fact, they've gone on to make statements saying that the corruption taking gigantic proportions. Also gone on to state that don't take any lenient view against corruption, because this would have a demoralizing effect on honest officers. But when we talk of the conviction, the Supreme Court on corrupt netas has said that the conviction can be based on circumstantial proof. For more on this, I'm joined in by my colleague Harish, who joins us on the phone lines. Harish, good afternoon. Talk to us more about these statements that the top court has made on corrupt netas.
Yes, very, very significant statement coming in from the Supreme Court. As far as corruption charges against public officials are concerned, Supreme Court has very categorically said that they cannot be let away merely on the ground that there is no direct evidence. In such a case, circumstantial evidence must be taken into consideration, and such a public official must go to jail. Supreme Court very clearly said that corrupt officials must be booked and convicted as corruption has taken a gigantic proportion affecting the governance and has a demoralizing effect on honest officers. Remember, such comments are very significant given the fact that it has come from a five-judge constitution bench of the Supreme Court, and the court has said that any court should not take lenient approach against the corrupt, and held that the corrupt public official can be convicted on the basis of circumstantial evidence alone when there is no direct evidence against him or her. The court was in fact pronouncing judgment on whether, in the absence of evidence of complaint or direct or primary evidence of demand of illegal gratification, a person can be convicted. In this pertinent case, in fact, the complainant had died just before the trial, and the Supreme Court was wondering the court can even go ahead with the trial. So this judgment was dealing with such an issue. The Solicitor General of India had said that this is precisely what the order referring the issue to Constitutional Bench had said. So today, the biggest takeaway is that Supreme Court has noted that corrupt officials must be booked and convicted, as corruption has taken a gigantic proportion affecting the governance and has a demoralizing effect on the honest officers. So even in the absence of a direct evidence, the circumstantial evidence must be looked into, and if it is very convincing, even in the absence of direct evidence, the corrupt public official can be convicted on the basis of circumstantial evidence also. So a very clear message coming out from the Supreme Court that the corrupt cannot be let away. It has a demoralizing effect on honest officials who are sincerely going ahead with their work, and therefore all the corrupt public officials should be brought to book and should not be let away merely because there is no direct evidence. So earnest efforts should be made by the probe agencies to dig out circumstantial evidence against them, and that if that is convincing, such a corrupt official can be convicted on the basis of circumstantial evidence also.
Harish, also talking about the five-judge constitution bench, which was headed by Justice S.A. Nazir, said that the complainants as well as the prosecution should make sincere efforts so that the corrupt public servants are brought to be booked and convicted. Can you talk to us about this particular development in terms of who also led the five-judge bench constitution when they came to this particular judgment?
Yes, in fact, this bench led by Justice Abdul Nazir was pronouncing judgment on whether, in the absence of evidence of the complainant / direct or primary evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of culpability or guilt of a public servant under the Prevention of Corruption Act 1988 based on other evidence adduced by the prosecution. So, as I said earlier, in this particular case, the bribe giver had died. So there is no question of proving the illegal demand made by him. The predicament was nothing could be inferred in the trial. So Justice Nazir, who at the bench had noted during the hearing what is of utmost importance is to examine is it the only way to prove it, or whether other evidences like circumstantial evidence can be taken into consideration during the trial, and if it is convincing, does it can we hold the official guilty? So the outcome is that they have said yes, in the absence of direct evidence, circumstantial evidence can be considered, and the official can be held guilty for corruption. Back to you.
All right, Harish, I appreciate you getting us those important details and breaking down that for us. But I also believe we have Arvind Galgali, RTI activist, joining us on the broadcast. Mr. Galgali, thank you for taking the time out and speaking to us on Mirror Now. This is, of course, a huge statement that has come by from the Supreme Court. How do you read into this?
निश्चित तौर पर सुप्रीम कोर्ट ने जो आज निरीक्षण किया है वो समय की जरूरत है, क्योंकि आज देश में चाहे मुंबई हो या जो अलग अलग जो केंद्रीय संस्थान हो, वहाँ पर जो भ्रष्ट अधिकारी होते हैं कहीं ना कहीं तो उनको बचाने का काम करते हैं। जैसे मुंबई में हम देखेंगे तो सचिन वजह जैसे लोगों को फिर एक बार नौकरी में रखा गया था, कहीं ना कहीं तो जो भी भ्रष्टाचारी है, जो गिल्टी पाए जाते हैं, उनको मानवीय दृष्टिकोण से जब इस तरह से पुनः सेवा में लिया जाता है तो कहीं ना कहीं तो करप्शन का दायरा बढ़ जाता है। और सुप्रीम कोर्ट ने जो निरीक्षण किया है ये कोई पहला निरीक्षण नहीं है, इससे पहले भी कई बार सुप्रीम कोर्ट हो, जो अलग अलग राज्य की जो कोर्ट हो, उन्होंने इस तरह के निरीक्षण किए हैं। मगर कहीं ना कहीं तो जो केंद्र की सरकार हो, राज्य की सरकार हो, उन्हें अपना दायित्व संभलकर इन भ्रष्टाचारियों को उस पदों से दूर रखना चाहिए तो डायरेक्टली पब्लिक से जुड़े होते हैं।
अनिल जी, और दूसरा सवाल मेरा ये होगा कि ये जो एक स्ट्रॉन्ग स्टेटमेंट आया है कि जो सर्कमस्टेंशियल एविडेंस है उसके तौर पे कैन बी कनेक्टेड इन करप्शन केस, कैन बी कन्विक्टेड, बैक योर पार्डन, तो आप उस स्टेटमेंट को कैसे व्यू करते हैं?
देखिए कि जब भी कोई धुआं निकलता है तो निश्चित तौर पर आग लगी होती है। कहीं ना कहीं तो जो अलग अलग कारणों की वजह से, चाहे वो राजनीतिक दबाव हो या कई बार जो सबूतों के आधार पर हो, लेकिन मेरा मानना है जब इस तरह की चीजें ऑन दी स्पॉट होती है तो वहां पर सरकार को एक्शन लेने की जरूरत है।
ठीक है, थैंक यू अनिल गलगली जी फॉर शेयरिंग योर व्यूज राइट हियर ऑन मिरर नाउ. दैट इज ऑफ कोर्स द रिएक्शन